Okay, this morning we're holding an informational hearing on the Minnesota Board of Judicial Standards. We've looked at our schedule and wanted to hear a little bit more on the work of the Judicial Standards Board, pardon me. And we will call them forward now for their testimony. So if I could have the folks from the Minnesota Board of Judicial Standards come to the testifying table. And good morning. Please introduce yourself and proceed with your testimony.
Thank you. Good morning. My name is David Paul. I'm the Executive Secretary to the Board of Judicial Standards. And I've been asked by Representative Szymanski and his staff to come down here and just generally talk about the work of the board, to answer what questions you may have. The Board on Judicial Standards is the only agency in the state of Minnesota that deals with complaints or processes complaints alleging that judges have acted inappropriately from a personal standpoint, and I'll get into that in a little more detail in just a moment. When a judge engages in personal misconduct, that is a violation of the Code of Judicial Conduct, which is a written document in the rules of court. And the board, in addition to that, also deals with disability cases. That is, cases which allege that a judge is sufficiently disabled in terms of mental or physical health, so as to make his or her tenure on the bench untenable. And we don't get too many cases like that. We did complete one last year in which the kind of the reverse happened. The judge thought that he was disabled sufficiently to be retired, and the governor asked us to look into it, and eventually the case was resolved on a private basis. The judge is now back to work, but that is pretty rare. Most of our cases are we deal with actual judicial misconduct. The jurisdiction of the board includes district judges, includes appellate judges, both the Court of Appeals and the Supreme Court. It includes any referees, child support magistrates, any active retired judges. The board's jurisdiction extends to any judge or any person performing neutral judicial decisional duties who are paid by the judicial branch. So, for example, the executive branch judges, such as unemployment judges, would not be under our jurisdiction because they are not paid by the judicial branch. There are also there are several types of executive department judges that are in our jurisdiction by agreement or kind of interesting way of phrasing statutes. The Minnesota Tax Court is within our jurisdiction, and that is purely by agreement. They are executive branch judges. The Workers' Compensation Court of Appeals is within our jurisdiction. Again, strictly executive department judges, yet they have agreed to be subject to the board's rules. And the administrative law judge, this is the interesting part in terms of statute, the Office of Administrative Hearings, which houses the administrative law judges and the district hearing workers' compensation judges, are not within our jurisdiction. However, the chief administrative law judge is within our jurisdiction, and in this case it's Judge Krause at this particular point in time. Because he's under our jurisdiction, part of the code is to supervise judges that you have the duty to supervise adequately from a standpoint of judicial ethics. And so, in a sense, all the administrative judges are kind of under our jurisdiction, but only through the fact that the administrative law judge, the chief administrative law judge, is under our jurisdiction. In addition, the board does, this is the main core function of the board, is to process these complaints and bring them forward where the board feels that that is appropriate to do. In addition, the board has a special assignment from the legislature, which it has had for many, many years, to enforce compliance with MS 546.27. Also, there are various other equivalents to that statute. For example, in the tax code, it's Chapter 270. But the statute basically is called the 90-day statute. In the tax code, it's the 3-month statute. But it basically says that any motion, any decision must be filed within 90 days of the date of submission, and submission, of course, being a term of art, referring to that point in time at which everything that a judicial officer would need to decide a case was in. All the briefs, all the testimony, everything in. And then at that point, the period begins to run. And the legislature, under that law, gives the board the first shot in enforcing that. So we get, unfortunately, we get 2 months late, but we do get lists of cases that have been decided late, and we pursue those along with other cases that we have. We also try to work with judges and judicial officers in a kind of an education program. We work with judges, we work with the general public, we work with the legislature to advise them of what the code says and what the procedures of the board are, very much like I'm doing now. And we also take phone calls from judges who have ethical dilemmas that they are trying to resolve. And I just give them informal advice over the phone and try to do the best job I can with that. And also the judge has the option, always, that judge or judicial officer has the option of sending us a more formal request in writing with a question. And at that point, we then respond in writing. And we have a number of, these are called informal advisory opinions. The board has issued many, many of them over the years. And they can be quite helpful. This year we have put together an index of all of these decisions, and I'm looking forward to publishing them on the internet fairly soon. I haven't done it yet just because of other priorities. Sometimes the work of the board gets very, very heavy in terms of volume, and sometimes these extra projects have to go to the wayside for a short while because I'm the only person in the board other than my assistant. But that index should be coming out fairly soon. I think the index has a big disclaimer on it saying that, you know, it's not a question of precedent. You can't take a decision by a former board and automatically say that it's going to be applied to a certain situation. The rules change, boards change, laws change, but it's a good thing to do, and it's better than not doing it. And so I'm happy to have the authorization from the board to at last do it. As I said, I work on the phone with judges. Of course, I work with citizens and lawyers also who have questions about the process or a certain item of conduct. Of course, we do the other administrative duties that are required of agencies. And that's basically the function of my assistant, my associate. She does the administrative and accounting functions. The board works pursuant to rules which the legislature gave the Supreme Court the duty to write, and they have existed for quite a number of years. The last time they were revised were in 2009. There were some important changes made at that time. One thing is always necessary to discuss when I'm talking about the activities of the board is it's the important limitation it has on its authority. And the problem is that people perceive the board often as either part of the court system or perceive it as having some kind of power over the court system, or perhaps perceive it as a dual function judiciary. In other words, it can do the same thing as the court. And that is not the case. The board has no authority. As a matter of fact, it's specifically limited, as are most similar boards, as are all similar boards and commissions throughout the country. Limited to personal misconduct. It cannot review a case for error and or mistake. There must be personal conduct, and it's an important distinction because so many people call me with these types of problems. They call up and they say, you know, what is happening here? The judge has ruled he or she is entirely wrong. I've taken a terrible beating in this case, and I know that you oversee the judges, so can you help me? And just on the basis of that information, the answer is no, because we have no authority, for example, to go to that judge and say, Judge, you made a mistake here, you must change this. Or, Judge, you have to rule this way. We have no authority to do that, because to do that would be actually be the same as calling us a court, which we are not. And courts, of course, are drawn by the Constitution, and we are just a creature of statute. But it is an important part of educating people so that they know that we cannot do something, and then what happens is that sometimes if they get the impression that we can, they don't do what they should do. Perhaps appeal the case or go back to the judge, go back to the court, and try to get it changed by appealing to the people who have the power. And so it's important. It's an important aspect of my duty, I think, is to try to explain that, and try to explain that limitation, and try to get people on the right track. Some people just don't want to accept it, but most people understand. They understand that there cannot be two judicial systems in our state, otherwise there would be hopeless amounts of conflict and all kinds of chaos. But it's the most important thing to remember about the board, is this important limitation on its authority. Examples of misconduct, and this is, I want to talk to people, I often give examples like this. Conflicts of interest, for example, if maybe within a short period of time a judge is trying to rule on a case where his or her former law firm is one of the parties, that of course extends out over time and eventually disappears just without more evidence, without some other factor interceding. Improper communication with one side. This happens quite a bit. The judge may all of a sudden call in a family law case a guardian, or have a private conversation, or something like that. It happens all the time, and it's the kind of thing that we do a lot of in terms of processing. Improper courtroom conduct is another. Demeanor is a consistent problem. The important thing to remember about our limitation is, and I try to make this very clear to everyone, just because we cannot look into a problem, a specific problem, because it is beyond our authority, that doesn't mean that the judge did everything correctly or didn't do anything correctly. All it means is that you have to go to the people who have the authority to decide that, and that, of course, is not us. And the interesting thing about it is that the types of things we do have really nothing to do with the actual decision. I often kind of bring up a dumb example with people I talk to. Of course, I warn them that dumb example is coming. But I say, you know, if your mother or your brother were sitting on that bench ruling on your case, you can see that that would be a problem. Of course, everybody agrees, yes, this would be a terrible problem. And I say, note that this person, your mother or your brother, could rule in your favor, or could rule not in your favor, but the problem would still remain. So, and it kind of exemplifies to people the difference between the types of things we do, which have nothing to do with the ultimate decision, and the types of things that courts do, which of course is all about deciding disputed issues. My basic procedure, typically I will get a letter from somebody, and or a phone call, but on a letter, I review the letter to determine whether or not there are any allegations in the letter that the board has the authority to process. And of course, if you get a letter saying that, you know, this judge, he ruled in the exact wrong way, he didn't pay any attention to the law, he violated my constitutional rights, he violated the Family Law Act, he violated the Landlord-Tenant Act. These are things which are important and must be resolved, but they cannot be resolved by us. So under the rules, I have the power to write them back and say, no, this is not something that we have the authority over. You must go to the courts for this. Most often, a letter has both. It has both allegations that we can't consider and allegations that we absolutely must consider. And this is the typical type of letter. And and so I automatically divide them up. Of course, I show the whole letter to the board and let it make the final decision. Most cases that we have are a combination of matters over which the board can exert its authority and matters over which the board cannot exert its authority. Let me just move on to the appropriation side of things, because this House and Senate passed a bill several years ago, which has made a tremendous difference in the operation of the board. Of course, consistently, the board's largest and most unpredictable and most inconsistent expenses relate to the investigations of serious cases and the public hearings which sometimes result. If the board finds that there is reasonable cause to pursue a matter, it does so. It proposes a corrective measure of some type, and usually those corrective measures are accepted, and these cases all resolve, and this happens about 98% of the time. Sometimes, however, the judge does not agree that the corrective measure proposed by the board is appropriate, and in that event, the judge or judicial officer has a full right to a very, very carefully run hearing, filled with due process protections, disclosure as to the evidence. It's a high standard of proof, the clear and convincing evidentiary standard, which is the highest standard you can have in a civil case. Of course, the criminal cases are much higher. But the board holds public hearings. Like any legal proceeding, the lawyers' fees are involved. We have to get a courtroom. We have to get court reporters. These things are expensive. They're all the necessary components of a hearing are paid for by the board. And of course, the board is not in direct control of when this is going to happen. So you might get a period of 5 years where it happens only once in a while. And then you can get a period like the last couple of years, which all of a sudden there were 4 hearings and something like 6 cases, and that was extremely complicated and extremely burdensome for the board and the citizens, because it was very expensive. Might point out kind of hopefully now that there's nothing on the horizon, so there does not appear to be any reason we have no hearings pending or anything like that. So it kind of is what I sat here and described it to be last year, which it appeared to be kind of a bubble, and it appears to be over. Of course, in years past, the board had problems because it did not have any money, it had no budget, a very small amount of budget, $15,000 to $20,000 to do these things. And we would get in these deficiency positions since these hearings could not be postponed with the due process standards. And we were constantly coming to the board with substantial deficit requests. And in, I think since 2002, I've been with the board since about 1999, but since 2002, we had made 4 deficiency requests, about 1 each session. And in 2008, the legislature passed a revolving appropriation line item for us, which is $125,000 per year. And it just kind of, we use it and it just kind of fills up the next year. So it's a total of, can be a total of $250,000 over a 2-year period. If we don't use it, it just goes right back. So with that money, we were able to do several things which I think in the long run save the state money. In that, before, in our deficit situation, we couldn't even hire an investigator. We had no money to do it. So we would impose upon our lawyers, who of course were waiting for their money, to do the investigation for us. So they would charge us at a reasonable rate, but at a rate that was obviously designed to make them some money, that profit. And of course, we could get these things cheaper if we had hired it directly ourselves. One of the terrific things that this revolving appropriation did is it allowed us to do that. And so we were able to investigate these cases preliminarily at a lesser rate. And that's been very helpful to us. And the board will forever be indebted to the legislature for voting that special revolving appropriation. Let's see, just a brief update as to what we've done. I have full statistics now for 2010, and I am working on the statistics for 2011 at this point, but the 2011 statistics will not be very different than these statistics which I'm about to review now. Just briefly, in 2010 we processed over 1,400 calls and letters from the general public and from lawyers. We processed 363 inquiries from judges and judicial officers. These are judges asking questions. We issued 4 advisory opinions. This is the more formal process that judges and judicial officers sometimes use to get an opinion from the board. We formally investigated over 120 cases. Again, this will be about the same for this year. We issued 2 public reprimands, 12 private admonitions, issued 9 letters of caution. Letters of caution are non-disciplinary types of letters in which the board expresses its view that some conduct might be a problem if it continued in the future. It's been a very useful tool. In terms of effectiveness of judicial oversight, Ryan Blodgett and Representative Szymanski, I think, wanted me to just touch on this because it's an important aspect. You know, there's been a big change in the board's rules from from and after 2009, July 1st, 2009. Prior to that, the board was able to stand apart from the process a little bit, was able to appear to be a little more neutral. It had, the panel for the public hearings only had the power to recommend to the board that a case be resolved in some way, and the board itself had the power to consider that recommendation, sustain it or not sustain it, and then recommend to the Supreme Court how the case should resolve. And the board would, again, usually, even after having caused the case to go to public hearing in the first place, now took the benefit of the transcript back with it, reviewed the code again. It was open. The decision was always open until the time came to give the recommendation to the Supreme Court. Under the new rules, things have changed. Now the board is more of a party. The panel has the power to make its rulings and to do so in a final way, unless, of course, either the judge or judicial officer or the board appeals. So the board's role is a little more advocacy in nature, not as neutral as it once was. But it's, I don't know how substantial a change that is. Has this rule change made a difference in the effectiveness of the board? I don't think so. There are definitely changes, but it's just kind of the same thing, only it must be pursued in a different way. From my standpoint, from the administration standpoint, the rules are still the same for me. I advise judicial officers about their questions. I don't tell the board about it, so that the judicial officer is comfortable knowing, in calling, and knowing that something that they may, in fact, turn out to be doing wrong would be able to be acted on by the board just by telling me, and that would not be a good way to put out advice. And so I still am able to do that. At the end of the day, I think that the board, regardless of what rules were pursued, in some of these cases were pursued under the old rules, some pursued under the new rules, I think the board was able to pursue what it felt was important. I don't have a vote in that, I just process them. But that is something I felt that the board did competently and accurately. Some boards are more active than others. Some courts are more active than others. Some panels are more active than others. The next board may not or may be as active as the previous boards. It remains to be seen. But what I'm trying to say here is that I think the level of activity on the board is very much dependent on who is on the board. And this changes over the years. It changes to some degree every 2 years. And in 12 years, I've seen many changes. I've seen boards that were not very active. I've seen boards that were extremely active. That is the key to how the board reacts. Some people may feel that the board, when it is in a more inactive phase, should be more active. Some people may feel the opposite. But no matter what position the board takes, you can be sure that there will be people on both sides to criticize or commend. Can I answer any questions for anybody?
Certainly, Mr. Paul. Representative Johnson has the first question.
Thank you, Mr. Chair. You were kind of getting it towards the end here, Mr. Paul, but could you say a little bit about the board, who's on it, and who appoints them, how long they serve, that sort of thing? Just have some idea of who this judicial board is.
Mr. Paul.
Chair. The board is made up of 10 people, one of which is a Court of Appeals judge, 3 of which are district court judges, 2 of which are lawyers, and 4 of which are people called from the general citizenry, not lawyers, not judges. They serve 4-year terms. The most they can serve is 2 terms. And about every 2 years, we see a change. The lawyers and the public members are confirmed by the Senate. The judges, however, are not confirmed by the Senate. They do not have to go through any confirmation process. All of the board members are appointed by the governor.
Okay. Representative Gruenhagen.
Thank you, Mr. Chair. Thank you for your testimony, Mr. Paul. I'm a lay person, so I'm not associated with the legal system. Most of my association has been playing basketball for about 10 years with 2 judges and some lawyers, okay? And if I followed them, they wanted to have or if I claimed I followed them, they wanted to have a short jury session to figure out whether it was true or not. But anyway, just kidding. Hey, just a couple of questions to help me better understand. So if a complaint comes into the board, and I have had some concerns and complaints by constituents about the Board of Judicial Standards and also the responses. So if a complaint comes in, my understanding is you issue a letter to them within a reasonable period of time, I assume, and then that letter or response is also posted on the internet, or you plan to do that in the future? Is that correct?
Mr. Paul.
Mr. Chairman, no, we do not ever publish letters that we get from anyone on the internet. Our board, this is something I probably should have spoke to earlier, our board works on a confidential basis. The only thing that we were publishing on the internet was the judicial opinions, the opinions the board had issued to judicial officers over the years. And we're not even going to associate any of those opinions with names. They will appear without names. Those are purely for education. No, the letters that you are speaking of are treated with specific confidence by the board and by me. And the reason is very clear. It is not easy to mount a complaint against the judge. Judges are very powerful in our society. And it has to be recognized that people who are not as powerful still may have complaints, and one of the most common issues is that they don't want to injure their cases. In many cases, the judge is still presiding over their case. And of course, they don't want necessarily the judge, some don't care. Some say, send this complaint to the judge, but most people are concerned that at least for the initial period, that nobody know about the complaint. And it's a good rule, and I'll tell you why. It gives a complainant, and I'm including lawyers and judges here too, because we get complaints from lawyers and judges in addition to citizenry. It gives all of these complainants a free look. It's a look. First of all, I take a look, and if the allegations are not something the board can handle, then it's treated a certain way. And by the way, when I write back to the complainants, those letters are always reviewed by the board. So if there's any mistakes made, they get corrected eventually by the board. But and then of course if the complaint does have allegations that the board may decide upon, then it does. These allegations go to the board, and if the board feels that there's not sufficient cause to go forward, or now they call it reasonable cause. Again, nobody tells the judge about the existence of the complaint, because that would just be counterproductive. And sometimes the judge knows anyway, because the complainant tells them, or maybe sometimes comes out in the news that somebody filed a complaint. But mostly the judge, 98% of the judges never know that complaints have been filed against them. And because there is the board does not find the reasonable cause that needs to go forward. But again, from a person of a standpoint who's filing a complaint, this is a good thing, because it gives them a look. It gives them a chance to test what their complaint is against what the board will do. And without, and I don't mean to imply that judges would hear that a complaint had been filed against them and become prejudiced and impartial and rule against them. That's rarely the case. And it's not only against the rules, but it's rarely the case. But yeah, it does happen, but it is rarely the case. But it makes people have confidence in the fact that the board will take a good look at their letters without having to deal with the issue of whether or not their cases may begin.
Representative Grunhagen.
Yeah, Mr. Chair, thank you for that response, Mr. Paul. You know, a lot of these concerns seem to center around, I would say this, and it tends to be in the area of a divorce court, okay? And I know those are extremely difficult situations with the allegations and the emotions and the children involved at times. But one of the consistent complaints is that they believe, you know, if a person believes that the judge is consistently ruling outside of statute, that they've done their homework, and according to what you've testified here today, if they file a complaint on that basis, that is really outside of your jurisdiction. And the only recourse for the person, if they believe that the judge is consistently ruling outside of the law, is to go back to the court system. Is that correct?
Mr. Paul.
Mr. Chairman, basically that is correct. If the only fact, let's just take a real theoretical case, if the only fact is the judge has ruled against them time and time again, that may not be something that is correct in terms of whether the rulings are correct. But it is nothing for us to consider, because we can't tell the judge, change the way you're ruling. We have no authority over that. And to do so would be, the board would be acting as if it was a court. And that, again, would cause a lot of problems.
Mr. Chair?
Representative Grunhagen.
Yeah, so if I understand that correctly, is there any, if a judge is ruling consistently in cases outside of the law, is there any organization or group that critiques those rulings, or is that left to the judicial system itself?
Mr. Paul.
Mr. Chairman, yeah, let me, and then before I answer that question, the answer to that question, I think would be no, because there can be no agency that can say anything about a judicial ruling as to whether or not it is proper or not. But I should probably qualify what I said to you before with regard to the other answer. There are cases where judges, for example, in criminal cases, refuse to appoint an attorney for an indigent person and do it on a periodic basis, do it in a pattern type of way, do it consistently. There's judges, there are judges who violate who do basically what you say, and if it's serious enough and if it's so outside their authority that it doesn't make any sense, that can be a violation of judicial conduct. For example, if a judge read a ruling and said, well, I'm not going to enforce that ruling. That ruling's stupid, I'm not going to enforce it. That could be a problem. I mean, because it's a direct ruling, and the judge is saying, I'm not going to enforce it. Why? Because of some personal reason. I mean, either a judge always has to enforce other rulings from the appellate system. I mean, to not do that could be a problem. There are those few cases, and I mean, when you put them all together, there's many of them. It's pretty rare, but there are those cases where judges act totally beyond their authority, and those cases can be considered by the board and have been.
Mr. Chair, Representative Grunhagen.
Just a final question. You talked about having issued 4 deficiencies in the last several years. When is the last time the board ever my understanding is if the board recommends removal of a judge, they have to recommend that to the Minnesota Supreme Court, and they actually act on that. Has there ever been a time where the board recommended a removal of the judge in the last 25 or 30 years, to your knowledge?
Mr. Paul.
Mr. Chairman, yes, there have been several requests. The most recent one would be in the case of Judge Karasov, where she was alleged to have and was ultimately found to have been living outside of her district in violation of the Constitution. Now, this was not this would not cause the board to seek her removal. Just move back in and, don't do it again, and there would probably be maybe some kind of public corrective measure involved, but it was not that big a deal. But she had communicated with the board in ways which the board felt was not honest, not genuine, and this again was also affirmed by court. But so in that case, the board sought her removal on the grounds that if a judge is not being honest with the board, what kind of authority can she maintain over normal people? Again, the Supreme Court did not agree. The Supreme Court suspended her for a very, very long time, 6 months unpaid, but they did not agree with the board. Another case would be the Judge Blakely case. There have been more than these cases, but these are examples. Judge Blakely, you may recall, or maybe you don't know anything about it, got a discount on his own lawyer's bill for his divorce by referring cases without telling anybody about it, without disclosing anybody about it, by referring cases to this lawyer and saying, and then writing an email to say, I've referred you all these cases, how about a discount? That kind of thing. We didn't think that was Judge Blakely should continue. Again, we were not sustained. So I mean, it does happen. And I just wanted to, if I may, just go back to another point. I mean, you said, Representative, that that you get a lot of complaints from people involved in divorces, custody battles. Actually, there are several leading factors. In the family law, it's usually over 30% in any area that we have complaints relating to family law. Another growing area is probate, where there's just tremendous emotions involved, and people are just so having such difficulty with it. You are absolutely correct that any type of emotional action which there's tons of them in the courts, becomes a category to the board, something that we recognize very, very clearly.
Okay, thank you, Mr. Paul. Representative Anderson.
Thank you, Mr. Chairman. And Mr. Paul, a couple questions for you. You said that you received 1,400 calls and letters. How many basically written complaints did you receive in 2010?
In 2000. We received, I don't quite have this broken down, we received about 124 complaints over which the board conducted some formal investigation. And we received something like 1,350 other contacts, most of which were calls, but some of which were letters. And I would say that maybe between 8 and 12 letters per month. I would say between 100 and 200 letters per year were received by the board, and the rest would be phone calls.
Representative Anderson.
Mr. Chairman, Mr. Paul, the complaint that I receive is that people send you these letters, these complaints, maybe the packets of complaints about judges, and then they don't hear back from the board. Can you address that issue?
Mr. Paul.
Yes, that is just not true. I respond faithfully to every letter I get. There is nobody who has written the board that was not received a response. There are people who, I don't think they're the type of people you talk to, people who send us like 10 faxes a week. They just, we talk to them a variety of number of times. They just don't want to accept what the limitations of the board is. But no, that never happens. There's always some response when we get a letter.
So,
Representative Anderson.
Mr. Chairman, Mr. Paul, in the letter that you respond to the people, then you do clarify that I can't deal with your complaint because it does not deal with something that's in our authority. I mean, do you specifically tell the person why you're not responding, why you can't do anything regarding their complaint specifically?
Yes, ma'am.
You put that in your letter. Thank you.
All right.
Thank you, Mr. Chair.
All right, next is Representative Lesh.
Thank you, Mr. Chair. Mr. Paul, I was friends after law school. A buddy of mine who clerked for a federal judge, and that federal judge is one of his favorite sayings on a particularly sunny summer afternoon. He'd say, I'm going to go play golf, and anyone who has a problem with that can go round up 67 senators, which, of course, you need to impeach. In the Minnesota system, of course, it's different. We hold judges accountable by elections. And I'm wondering, when people are frustrated with a particular judge's conduct, whether it is a matter of law or personal misconduct, are you familiar with situations where these individuals, in being unable to secure some kind of relief they want through your board, that they have successfully mounted a campaign to defeat that judge at the ballot box?
Mr. Paul.
Chairman. Representative, I'm aware of several cases like that. It's interesting that you bring that up. Under the code, it is a state judge's duty to give his or her first priority to the job, not to playing golf, but to the job. It doesn't mean a judge can't play golf, but it certainly means that a judge can't prefer other activity over the activity of presiding in cases. And that is part of the Code of Judicial Conduct, a very strong part of it. Yes, there are several cases where judges have been overturned I assume you mean in connection with, or judges have failed to obtain re-election after they had been disciplined.
Or even anything brought,
Representative Lesh.
thank you, Mr. Chair, or anything that was even brought to your board that didn't rise to any other kind of complaint level or what have you. So yes, that failing to be disciplined would be one option.
Mr. Paul.
Through the chair. There are several examples of the first case that you mentioned. There may be examples of the second category of case that you mentioned where the board acted with regard to a judge and did not work in a public manner, but work in a private manner. And that judge may have been unsuccessful at the next election. I think that there are such cases. I can't be specific, so I don't want to be able to say that there have been cases for sure, but I think that there have been such cases.
Thank you, Representative Lesh. No further questions?
Great.
Representative Smith.
Thank you, Mr. Chairman. Mr. Paul, let me get this straight. Hearing your testimony, I have a question, and I think you can answer it in one word. I think it's probably going to be yes. But in response to a previous representative's question, you constructed a hypothetical about someone writing you with a complaint that the judge time and time ruled against them. I believe I heard you testify that your function, your role, and your authority is to investigate and help correct a judge who has acted intemperately from the bench or arrogantly or prejudicially, not to make a finding if the judge ruled outside of a statute or did not provide justice. That person's area of redress is to the next higher court, Court of Appeals or Supreme Court, but not you. Isn't that correct?
Mr. Paul.
Through the chair, the answer to that question is yes. My only qualification is there are those cases, as we discussed, where a judge acts completely beyond his or her authority. And that, those types of cases that we discussed. those can be exceptions to that. But if you don't have that fact, you don't have the fact of the judge acted beyond, or the allegation of the judge acted beyond his or her authority. If you the only fact you have is that this judge ruled consistently against a certain person, really it isn't very much we can do with that. It's not for us to do.
Thank you.
All right, Representative Leadley.
Thank you, Mr. Chair. Mr. Paul, I have a couple areas I want to ask you about. The first is about just general supervision of judges, because it's been my observation for some time that there's really nobody who provides sort of daily supervision of the work of judges. For example, in judicial districts, there's a chief judge, but that chief judge does not supervise the other judges. For example, things that might not rise to the level of coming to your board, such as, you know, a judge who, say, is late every day or disappears on Thursday afternoon to golf or something like that. That there's nobody really whose role it is to simply say to that judge, you know, you really got to shape up, this doesn't look good, this isn't good, we don't want this, you know, to sort of shape their behavior short of making a formal complaint. So I'd like you to comment on that first of all, if you see that as an issue. And then I have another question as well, Mr. Chair.
Mr. Paul.
Mr. Chairman, thank you for saving your second question, because the answer to this one is a little bit involved. You know, you are generally correct in saying that judges have no supervisor. Yeah. They have the higher courts to determine whether or not they made correct rulings, but they are elected officials. And it is a problem. I mean, it's not to say that a chief judge or some other judge, some mentor judge somewhere, or just a judge who's a friend of another judge hasn't gone up to a judge and said, you know, you're showing up late all the time, or you're playing a little too much golf, you're neglecting your duties. I mean, I have several cases like that right now. That's the interesting part. Judges do talk. They do try to help each other and try to assure that each of them acts within the purview of the code. But you know, interestingly, I have cases like that, right? I have a case, at least several cases right now, and I've had cases where just judges have been consistently late. There's cases where judges would not show up for several weeks. You know, these cases do get to us. There are also those cases that take place which do not get to us. But it doesn't mean that there's not something being done. Of course, sometimes nothing's being done and something should be done. But you have all these factors swirling around. But we do get some of these cases, and judges also help each other without regard to us.
Representative Leadley.
Thank you, Mr. Chair, and Mr. Paul. Well, yeah, and you know, I'm sure that's the case, off of the case. I'm not sure I think it's good that we don't have a system in place, because it's kind of happenstance, right, whether somebody's colleague says something to them, and often people don't want to do that. But anyway, my second question is whether, how we compare to other states. Do other states have more, what we might call robust systems of disciplining judges? Do they do it pretty much like we do? Can you just give us a really brief, I know there are 50 states and it's hard maybe, but you must have some idea of where we fall in the scheme of things.
Mr. Paul.
First of all, let me just address the first comment you made, which you said that you were disturbed because the system is a little happenstance. It's a little, and you're right. I mean, a complaint system is always going to be happenstance, as you put it, because it depends on a complaint. Some people file complaints and some people don't. I always try to encourage the filing of complaints, because without them, we never know what happens. At least if they're gone through and they're rejected, at least we've done that. But some people have what I consider to be very serious allegations of misconduct and never file complaints. Some people don't and file complaints all the time, but that's what we have with the complaint system. As to other states, I think this is a good question and a good opportunity for me to place the judiciary in Minnesota in some type of perspective, because we have serious cases in Minnesota. we don't have very many serious cases in Minnesota, and the cases that we have in Minnesota are not like the cases that you see across the country. I mean, if I could sit down with you for a half hour and tell you some of the stories that, these are not really stories, they're actual cases that come out, you would be shocked at the poor level of judicial behavior in other states. From the standpoint of what we do here, we're very happy with the level of personal conduct in the judiciary. There was we were in the Supreme Court not long ago arguing a case. One of the judges said to our lawyer, well, this is not a case that we get all the time. And our lawyer said, yes, and we're very happy about that. And it really shows that when we get a serious case, it is not a very common occurrence.
Okay. Thank you, Mr. Paul. Representative Allen, you have a question? I urge you to keep the question and the answer brief. We have several other people that want to testify today.
Mr. Chair, Mr. Paul, my question is, I understand that if you can't review a particular ruling and that would be subject to appeal and that should be decided by a higher court, but you keep talking about this exception about that if a judge is acting, so is it if a judge is ruling outside their authority or acting outside their authority? I'm trying to figure out give me an example of that.
Mr. Paul.
Mr. Chairman, yeah, this is a difficult area. I mean, if, let's say, a person feels that they should be able to pursue their case without filing fees, and the status of that is a Latin phrase called informa pauperis. It's not, you don't have the money you can proceed without the filing fees because you don't have the money to pay them. And we get a lot of complaints about those types of things where they're ruled against. And, you know, the thing the board watches for is there a scenario in which the judge's decision could be justified? And if there is anything at all, and if it is within the judge's authority, I mean, if the judge rules on that particular issue and it is within his or her authority, it's not going to be easy, it's going to be impossible for the board to act on it. It's just these cases where, and they're more, you'll know them when you see them. It's when the appeals court comes down and says, you must rule this way, you must do this. And the judge just said, well, I'm not going to do it. You know, it's that kind of a blatant thing. And it's difficult to describe, it's not as difficult to recognize.
Thank you, Mr. Paul. Our next testifier